Okay, so this is an exam question taken from an earlier paper, but we're going to have a look at it anyway because it's something that would spark relevant discussion and something you could talk quite a lot about in the exam. And it's asking, to what extent are judges better guardians of rights and civil liberties than Parliament or the executive? And this should really immediately strike up some some thoughts in your mind. What can you talk about? So for one, what do we mean by rights and civil liberties? Well, we're just going to talk mainly about human rights. So human rights. Human rights. Although this does not necessarily refer to just the Human Rights Act, we've also got things like the Freedom of Information Act. And what do we mean by judges? So there are a lot of judges that we can draw on. Mainly what we would want to look for is the law lords and the Supreme Court. So the Supreme Court, we're going to look at some cases from the Supreme Court. However, we're also going to look at certain cases from the ECHR. Okay, so the European Court of Human Rights. So we'll have a look there as well. And really we're going to just split it into two. We're going to look at why judges might be better suited for protecting civil rights and civil liberties, and then why Parliament and the executive might be better. So we're going to start by looking at why judges might be better. So why are judges better? Why are judges better for protecting civil rights and civil liberties? Oopsie daisy. Well, there are a number of sort of pragmatic reasons you could talk about. So you could talk about, i.e., that judges are supposed to be, and institutionally they are, independent. So independent. And this comes from things like the JAC, the Judicial Appointments Committee. It comes from things like the guaranteed salary. Okay, things like that. So that's why judges might be independent. And independent means that they have the ability to apply the law where they can and not have any kind of bribery from government to apply the law in their favour. They're also supposed to be politically and ethically neutral. So politically and ethically neutral. Okay, and you can see that. It is very people who argue that they're not politically neutral. They've got a very hard time explaining why, because when you look at different Supreme Court cases, they make their judgment based on the legal merits of the case, and the same with the ethical neutrality. If the law says one thing, they're going to follow the law, not their own personal ethics. Okay. And now we can also have, they've got the ability to strike down laws that are seen as incompatible. So they're allowed to rule incompatibility. So rule against the government when it comes to incompatibility. So rule against the government effectively. And there are a number of things we're going to look at. We're going to look at the first case here, which is Gadian and Mendoza, 2004. So we're just going to let me just write this down here. So Gadian and Mendoza, or Gaydon and Mendoza, 2004. And now this was a case which concerned the Rent Act of 1977. So concerning the Rent Act of 1977. Okay, and the Rent Act allowed only heterosexual partners to succeed to a tenancy after the death of one of those partners. So we'll just talk. So when writing this out, I'll write it all out because it can be something that can be quite complicated to get your head round. So it's only allowed. So the Rent Act only allowed heterosexual partners partners to succeed to a tenancy after the death of one of the partners. To succeed to a tenancy following one partner's death. This is death. Okay. Now, it doesn't take an expert to work out whether or not this is, incompatible. And that's why it was held in 2004 in the case that by the House of Lords. So the House of Lords, don't forget, when we say the House of Lords in 2004, we're talking about the Law Lords, which was effectively the Supreme Court, but was only that sat in the House of Lords. So there's a little bit of a disagreement. There's a little bit of a distinction to be made there. So the House of Lords held that it was incompatible. So incompatible with Articles 8 and 14 of the ECHR. So with Articles 8 plus 14 of the ECHR. And we can see here that we've got a conflict there between the government legislation and with the ECHR, with the Human Rights Act. Okay, so this is the first example of an interesting case that can be used against that. There's also a very, very interesting case when we look at challenges to government. We can look quite a lot at terrorism legislation and the way in which the government and the courts conflict with each other when it comes to anti-terrorism. And one of the most interesting cases really regards the Secretary of State for the Home Department and JJ and Oars. Okay, so we're going to write all this out here. So Secretary of State for the Home Department and JJ and Oars. Okay, this was in 2007. Well, I'm not going to write out all the facts of the case. I'm just going to read them out to you because there's quite a lot to go through here. So this case really rested upon the idea of the deprivation of liberty. Deprivation of liberty. Okay. So the applicants were held under control orders as part of the Prevention of Terrorism Act 2005. So the Prevention of Terrorism Act 2005. So these were people who were suspected of terrorist activity, who were held under the control orders and restricting their personal liberty, so they couldn't go anywhere. And this was for an undisclosed amount of time. So the controlees argued that the restrictions amounted to deprivation. So deprivation of liberty, which is part of Article 5. So Article 5 of the ECHR. So it became. So the question was whether or not the Prevention of Terrorism Act and the ability of the Home Department to hold people using control orders for an indefinite period of time, whether or not that was in conflict with Article 5 of the ECHR, which was the idea that, prevention of the deprivation of liberty. So really, what was held by the Supreme Court, or the Law Lords, was that a previous Italian case, so a previous European case of Guzzardi and Italy would apply. So Guzzardi and Italy applies. Okay. So really what this meant was this held that the case had to be decided on its fact. So in this case, particularly the 18-hour curfew, which was really what was being decided upon, whether or not that was deprivation of liberty, they agreed that it was amounted to the deprivation of liberty, and so the control order was flawed. So what Guzzardi in Italy, the case there from the 1980s applies. It said that the case had to be decided on the merits of the facts of the case. So The facts of this case was, in this particular example, 18 hours was seen as a word of detention was being imposed on these people under the Prevention of Terrorism Act, and therefore the court decided that that was amounted to a deprivation of liberty, and therefore the order was flawed. So we've got two cases here that we can look at where we see examples of the courts protecting the rights of individuals against government. So the first case being the protection of homosexual and, giving really equality, homosexual equality. And then in the second case, we've got the sort of conflict when it comes to terrorism legislation. So these are all examples in which case where the judges have seemingly been able to better protect citizens' civil rights and liberties. We can look at the counter to this argument though. So why not? So why are they not? Okay. And really there are a number of points we can look at here. There are a number of more conceptual points, more also constitutional points as well. So we've got to really deal with the sticky issue of parliamentary sovereignty when we look at these. So parliamentary sovereignty. It's particularly interesting because even though the courts are able to apply the Human Rights Act and imply sort of articles of incompatibility with primary legislation, Parliament is ultimately sovereign. It was Parliament that passed the HRA, it was Parliament that passed the Human Rights Act, okay, and Parliament could just as easily revoke the Human Rights Act tomorrow if it got a majority. So, therefore, the resting will of the judiciary, all these cases that have been were decided on the merits, were granted by Parliament to the courts. The power was given to Parliament by the courts. So that's an interesting point there, that ultimately the judges are protecting using legislation that was created by Parliament. Parliament could also simply just ignore Parliament could also just ignore the cases, could just ignore them, ignore the rulings, okay? And this has been seen by a relatively recent case in Hurst and UK, so Hurst and UK, where the ECHR found it was a human rights violation to restrict prisoners' rights to vote. And the government at the time and the subsequent governments and subsequent parliaments have said, well, no, we're still not going to give prisoners the right to vote, and therefore, it was ruled. However, it was still Parliament never enacted it, and neither did the government, any of the governments, in fact. And then finally, we've also got the issue of the royal prerogative. So the executive is so the Prime Minister has the power of the royal prerogative. So the Prime Minister has the power of the royal prerogative. And this is obviously a very important power. It comes directly from the monarchy, and using this power, the Prime Minister and the government can effectively, there are a number of things that the government can do. However, it must be said as well that this was challenged, the extent to the royal prerogative, the powers of the royal prerogative were challenged in a very recent case of R. Miller and the Prime Minister, okay? And this was in 2019. This was last year, and this was effectively the very famous, almost landmark Supreme Court case, which was looking at the ruling of the prorogation of Parliament. So Parliament was being prorogued for an indefinite, not necessarily indefinite, for an extended period of time, arguably to sort of hamper negotiations and to hamper debate around the Brexit deadline, and therefore it was challenged. It was ruled as, it was ruled as unlawful, and then it went to the Supreme Court, and the Supreme Court agreed and ruled it unlawful, and they had said that Parliament had effectively not been prorogued. Now, what's interesting here is this. You could talk about this as part of a sort of a civil liberties issue, because it is the Prime Minister acting using the royal prerogative to attack the legislature in Parliament, something relatively undemocratic. And if you talk about the sort of rights to vote, the rights to be represented in government, you could sort of make the point here that the Prime Minister was trying to restrict the rights of the individuals by restricting the rights of their representatives. And the Supreme Court came in and ruled it unlawful. So that's another issue. That's an issue that you could talk about there. If you want to make this argument, you can make the case that this is could be construed as a civil rights, sort of a liberty issue, a right to be represented in the legislature. However, there's no formal right of that. And it's also, you don't even necessarily have to make this argument about civil liberties, specifically about the question. It's talking really about the power of the prerogative and the power that the courts have had over the prerogative in this one single case, and in ruling which, whether or not it's lawful. So it's really could talk about the fact that it's a conflict between government and the courts. So arguably, there's a lot you could talk about. There's a lot you could rest on. You could land on really either side of this debate. And you've got a number of cases here to do with whether or not why the judges have been better. There are almost endless numbers of Supreme Court and House of Lords cases, and even ECJ, European Court of Justice, and the European Court of Human Rights. There are a number of different cases in which you can look at and see the government being seeing the judiciary protecting the rights of civil liberties. But you could also argue more pragmatically that parliamentary sovereignty ultimately means that Parliament has the right to, withhold the rights to all of these powers. And so too, you could talk about the ability of Parliament to just ignore a lot of legislation, and then obviously the powers of the executive. So there's plenty you could really talk about here and argue on either side of this debate.